If you own any property in the United States right now, you need to hear this immediately. June 2026 is not just another month on the calendar, it is a hard deadline, a legal cliff. And right now, sitting on your desk or buried in your email, there are three specific real estate documents that you must submit before this month ends. Or you could lose thousands of dollars in penalties, trigger unexpected tax bills, or watch your legal protection over your own property evaporate into thin air. I am not exaggerating. Every single year, tens of thousands of American property owners discover too late that they missed a filing window they did not even know existed. And June 2026 is shaping up to be one of the worst years for this because of regulatory changes, mid-year assessment cycles, and estate planning windows that are slamming shut faster than most people realize. Before I get into this, hit subscribe and turn on the bell right now, because every single video on this channel covers the kind of deadline-driven financial and legal information that property owners cannot afford to miss, and you need to see it the moment it goes live. If you own any property in the United States right now, do not close this video until you have heard every single one of these. So why June 2026 specifically? Why is this month more dangerous than January? More urgent than December? Here is what most homeowners never understand until it is too late. The United States property system runs on two separate clocks that most people only notice one of. You have your annual tax calendar, sure. Property taxes due in the spring, assessments in the fall. But then you have this hidden mid-year cycle that almost nobody talks about. June sits at the exact halfway point of the fiscal year for most counties and states. That means assessors are closing their books on the first half. It means transfer records are being reconciled. And most importantly, it means certain legal filing windows that opened back in January are now preparing to lock shut forever. Let me put this in plain English. A filing window is simply a period of time when the government allows you to submit certain paperwork without penalty. Miss the window, and you do not just pay a late fee. You lose options, you lose protections, you lose the ability to correct mistakes that could cost you everything. In 2026, several states updated their property transfer laws, their homestead exemption rules, and their estate planning documentation requirements. Those changes took effect at the start of the year, and the grace period to comply under the old rules expires at the end of June. After that, you are operating under the new system, and if your paperwork is not aligned, you are exposed. Stay with me because in just 2 minutes, I'm going to tell you about the second document, and this one shocks most property owners because they never even knew it existed. And if you are watching this and thinking this does not apply to you because you only own one home, or because you inherited your property, or because you have a great accountant, I need you to understand something. The property owners who get hurt the worst are the ones who assumed they were already protected. Now, before we get to the three documents, I want you to do something. Pause this video for 3 seconds and comment below which of these documents you have already filed and which ones you had never heard of before today. I read every comment, and your answer might help another property owner realize they are in danger too. Let me tell you about the first document. It is called the Certificate of Title Update and Tax Alignment Filing, commonly referred to as the. This document does one critical thing. It forces your local tax assessor's office to officially reconcile your property title with your current tax status. Why does this matter? Because every time you refinance, inherit, transfer partial ownership, or even add a spouse to your deed, there is a gap between what the title says and what the tax rolls say. Most homeowners have no idea this gap exists. The county does not send you a warning letter. Your mortgage company does not check it. It just sits there growing until the day you try to sell. Take Michael from Texas. He owned a rental property for 12 years. He never filed this one document. When he tried to sell in June 2026, he discovered he owed over $34,000 in back taxes he had no idea about. The title was clean, the deed was fine, but the tax alignment was broken. And because he missed the June filing window, he could not contest the assessment. He had to pay it, every penny. That is what the CTUTA protects you from. It is a simple one-page filing, usually submitted to your county recorder or assessor's office, and it costs nothing or next to nothing. But without it, you are driving blind. Now the second document. Remember I said this one shocks people. This is the Intergenerational Property Transfer Declaration, or the IPTD. If you have ever thought about passing your property to your children, your grandchildren, or even a trusted family member, this document is the gatekeeper. It establishes the legal basis for how your property will transfer upon death or during your lifetime, and it locks in the tax basis, that is, the value the government uses to calculate capital gains taxes at the moment of filing. Without it, your heirs could face a massive tax bill based on the property's current market value rather than the stepped-up basis they are legally entitled to. Let me say that again because this is where families get destroyed financially. Without the IPTD, your children could inherit your home and owe capital gains taxes on decades of appreciation that you already paid for. Take Susan from Florida. Her father passed away in early 2026. He owned a home in Orlando that he bought in 1985 for $80,000. It was worth $400,000 when he died. Because he never filed the IPTD, Susan had to pay capital gains taxes on $320,000 of appreciation. Her tax bill was over $70,000. If he had filed this document before June, she would have owed almost nothing. This is not a loophole. This is not a trick. This is a standard legal protection that most Americans have never heard of because nobody tells them. And coming up, I will reveal the one filing mistake that real estate attorneys say they see every single June without fail, and it costs homeowners everything. But first, if you are watching this and you know someone who owns property, a parent, a sibling, a friend who just bought their first home, share this video right now, not later, right now, because they are probably in the dark about this too. And the June deadline does not care that they are busy. The third document is the Homestead and Primary Residence Reaffirmation Statement. This one sounds simple, and that is exactly why so many people ignore it. In 2026, over a dozen states changed their homestead exemption laws. A homestead exemption is the legal protection that shields a portion of your home's value from creditors and reduces your property tax bill. If you filed for homestead exemption years ago, you probably think you are done. You are not. The 2026 changes require every homeowner to reaffirm their homestead status by June 30th, even if nothing has changed. If you do not, your exemption lapses. Your property taxes go up immediately. And if a creditor ever comes after you, your home is no longer protected. Take David and Linda from Ohio. They filed for homestead exemption in 2010. They never moved. They never changed anything. But in June 2026, they got a letter saying their exemption had expired due to non-reaffirmation. Their tax bill jumped by $4,200 for the year. And when a medical debt collector came knocking 3 months later, their home was fully exposed. They lost their protection because of a one-page form they never knew they had to refile. That is the third document. 3 pieces of paper, 3 filings, and 3 completely different ways to lose everything you have built. Now here is the step-by-step action plan. I want you to write this down. Number 1, obtain the CTUTA form from your county recorder or tax assessor's office. Most counties now have it online. Search your county name plus certificate of title update. Fill it out with your current legal name, your property's parcel number, and a brief statement of any changes made to the title in the past 5 years. Submit it in person or by certified mail before June 30th, 2026. Keep your receipt. Number 2, download the IPTD from your state's Department of Revenue or Estate Planning Division. You will need your property deed, your most recent tax bill, and the Social Security numbers of your intended heirs. This form must be notarized. Do not wait until the last week of June because notaries get swamped. File it with your county clerk and send a copy to your state's revenue office. Number 3, request the homestead reaffirmation statement from your local tax collector. It is usually a single page. Check the box confirming your primary residence status, sign it, and submit it online or in person. Most counties process this instantly, but do not assume. Submit it by June 15th at the latest to give yourself buffer time. And here's the one filing mistake that attorneys see every single June. Homeowners submit these forms to the wrong office. The CTUTA goes to the recorder, not the assessor. The IPTD goes to both the clerk and the state revenue office. The homestead form goes to the tax collector. Mix these up and your filing is invalid. You think you are protected. You are not. Double check the submission address. Call the office if you are unsure. Do not trust a website that has not been updated since 2022. Let me be completely clear about what happens if you wait. These deadlines are real. They are legally binding. They are non-negotiable. July 1st, 2026 is not a suggestion. It is a wall. After that date, the grace periods close. The old rules no longer apply. The protections you thought you had are gone, and the government does not send reminder texts. They send bills. They send liens. They send notices that your exemption has lapsed and your tax basis has reset. And by then, the only person who can help you is an attorney charging $300 an hour to fix what you could have prevented with 3 pieces of paper. Every week you wait, the risk compounds. Assessors finalize their rolls. Transfer windows lock. Exemptions expire. And you are left holding a property that costs more to own, more to sell, and less to pass on. If you have made it this far, you now know exactly what is at stake. You know the 3 documents. You know the deadlines. You know the mistakes to avoid. But knowing is not enough. You have to act. So here is what I need you to do right now. Subscribe to this channel and turn on the notification bell so you never miss a deadline critical update like this one. Share this video with every property owner you know, your parents, your neighbor, your friend who just closed on a house last month. They need this information, and they are not going to get it from a billboard. June 2026 is almost over. The clock is running, and the only thing standing between you and a financial disaster you never saw coming is the decision you make in the next 24 hours. Get those documents, fill them out, submit them, and protect what is yours before it is too late.